Hello, everyone, and welcome to Uncivil Law. And for today's story, we're going to talk a little bit more about that high school stabbing that occurred at a track meet in Texas. We discussed this based on news articles recently, but now I have a copy of the police report, and so we're going to go through the police report because it presents at least primary information relating to the incident, and so we can see a little bit better at least what the police think happened, which isn't necessarily the complete story, of course. But we can see what they think happened and understand a little bit more about the factual predicate with some tentative statements about what we think the facts are, at least as they're known at this time. So we'll go ahead and do that. We turn our attention to the case of, what's this guy's name? Karmelo Anthony. And this relates to this high school track meet stabbing. By the way, just, basic pattern. They were at a track meet. This guy stabbed the other student. He's being charged with murder, and we're going to try to figure out if there's any sort of defenses that sort of apply. So we'll do that. All right, so here are the facts relating to this. On April the 2nd of 2025 at 10 o'clock in the morning, I, Stanley School Resource Officer E. Cortez, heard over radio dispatch call a stabbing call at David Dendal Stadium. The call notes that indicated that an athlete was stabbed. The suspect was reported as being a black male wearing a gray hoodie and blue sweatpants. I immediately left my office and ran across the Stanley Middle School parking lot towards the south entrance into the stadium. As I entered the stadium, two high school age students informed me that the victim was on the north end of the stadium by the bleachers under Memorial High School tent. I did not identify these students because, obviously I was in a rush at the time. Next, I proceeded towards the north end of the stadium, visitor side, on foot. As I got closer to the north end, I could see the Memorial High School tent with multiple individuals under the tent. Once I arrived onto the north side bleachers, an adult male who was on the track pointed out the suspect. I was not able to identify that witness. Again, in a bit of a rush. The individual that was pointed out to me was black male wearing a gray hooded sweatshirt and dark colored Nike pants, which basically meets the description I was given over the radio. So it's like, okay, that looks like it might be my guy. The suspect at this point was on the track on the north end. There was a chain link fence that separated me from the suspect. I gave the suspect instructions to keep his hands up in the air. During this time, the suspect said verbally out loud, "I was protecting myself." Okay, well, yet to be decided, but we'll see. It should be noted I had not questioned about the incident when he made that comment. So we're just getting way past our Miranda issues, right? Spontaneous admission. Spontaneous admission. So no questions, no Miranda, no problem. He just said things. So yeah, yeah. I asked him if he had weapons. He said no. I patted him down for weapons while we were walking along the fence, and I did not locate any on his person. I instructed the male to continue walking along the fence, which he complied, towards an area where there was an opening in the fence that laid off the track. While walking him off the track, the suspect also said he put his hands on me. Further spontaneous admissions. I then detained the suspect in handcuffs, handcuffed behind his back, and had him sit down on the ground. Officer A. Ritchie arrived at the scene at around the same time. I conducted another pat-down of his person and then searched his person. After he gave me consent, no weapons were located. While the suspect sat on the ground, I advised that I had the alleged suspect. The suspect then responds saying, "I'm not alleged, I did it." Again, I wasn't asking him a question. I was relaying it over the radio or to the other officer, and he just said, "Yep, it was me." Okay, fair enough. Okay, you're our suspect. Noted. Okay, where were we? Next, Officer Ritchie and I walked the suspect to a patrol vehicle, Officer Ritchie's patrol vehicle, which was on the north end of the gate of the stadium. As we were walking to the squad car, the suspect was emotional and said, "He put his hands on me. I told him not to." More spontaneous statements. I did not question the suspect about the incident while he was being escorted. No questions, no Miranda, no problem. I searched his person once again and had him sit in the backseat area of the patrol vehicle. While the suspect was in the backseat, I noticed fresh blood on his left middle finger. I verbally acknowledged I saw blood out loud so it would be captured on the body-worn camera. It should also be noted the suspect asked me Is he going to be okay while in the back seat? Perhaps some consciousness of guilt there too. I then identified the suspect. He provided me his name and date of birth verbally as Karmelo Anthony with a date of birth, which I ran through dispatch. Officer J. Hancock arrived on the scene and remained with me and the suspect at this point. Karmelo was then checked out via eSchool, the database for the students, to confirm his identity. The identifying information he provided matched the individual I had in custody. Next, I was advised by Sergeant Holland to transport the suspect to the Frisco PD jail. Officer Hancock and I transported to them jail. Again, I did not question him about the incident. Upon arriving at the jail, Karmelo was escorted into the intake area. The jail staff changed him into a jail attire. I remained with the jail staff the entire time as he was changed over. The clothes that Karmelo was wearing were placed in an evidence bag. Obviously. The clothes remained in my possession from this point on. Upon Karmelo being placed in the jail cell, I continued to keep possession of his clothes. I returned to my patrol along with Officer Hancock, which was in the Sally Port, and placed Karmelo's clothes in the back trunk area. I drove the patrol vehicle out of the Sally Port and parked the squad car in the parking area. Karmelo's clothes remained in the trunk area of the vehicle. FPD crime scene technician then took possession of the clothes. I add my body-worn camera to the case. I have no further information to report. Pretty simple arrest report. No muss, no fuss there. Then we have a supplemental report from Officer Ritchie. So Ritchie would like to add his thoughts to the conversation. So this is what he wants to add to the equation. On April the 2nd of 2024 at 10 o'clock in the morning, I, Officer Ritchie, was wearing a full Frisco police uniform and was operating a fully marked Frisco police vehicle. Around that same time, I was dispatched to a report of a stabbing at the stadium. Frisco police dispatch advised an athlete had been stabbed. The suspect was described as a black male wearing a gray hooded sweatshirt and blue sweatpants. I responded code 3 from the area of El Dorado Parkway in Frisco. I arrived at the scene at approximately 4 minutes later. While on the scene, I approached the track field area and saw Officer Cortez kneeling next to a black male wearing a gray hooded suspect and blue sweatpants. The male, later identified as Karmelo Anthony, was in handcuffs and was seated on the sidewalk by the entrance to the track. As I approached Officer Cortez stated Anthony was the alleged suspect. Anthony then made a spontaneous statement and said, "I am not alleged, I did it." Officer Cortez conducted a pat search of the person to ensure Anthony did not have any weapons and found nothing of evidentiary value. Officer Cortez and I then walked Anthony to my pre-searched patrol vehicle, and Anthony was seated in the rear driver's seat compartment of the patrol vehicle. While walking to my patrol vehicle, Anthony made another spontaneous statement and asked if what happened could be considered self-defense. Probably not, Anthony. Probably not. It's not looking really great for you, to be honest. I replied by telling Anthony I did not know what happened, which, fair enough. Also, I can't offer a legal opinion. Lol. It should be noted that the in-car camera in my patrol vehicle was acted prior to being placed in the patrol vehicle. While Officer Cortez assisted Anthony into my patrol vehicle, I noticed Anthony had blood on his left middle finger. I grabbed my department-issued digital camera and took a photograph of his hands. I later uploaded the photograph to the crime scene folder under the case. Sounds like pretty reasonable procedure by these police. Maybe they can give the Canton police some notes. I also notice at this point a lack of solo cups. Unclear whether or not Texas police have invented solo cup technology yet. But none appear so far. Officer Cortez remained with my patrol vehicle and Anthony while I provide assistance with scene security. Nothing further from this officer. Okay, great. We have statements from a third officer who would like to offer his thoughts on the subject. So Officer Otis would like to add to the equation. On Wednesday, April the 2nd of 2025 at around 10 in the morning, Frisco police officers were dispatched to Frisco Independent School District at the stadium in response to a stabbing call. Frisco Police Department Emergency Communications was receiving an emergency call regarding an athlete who was stabbed. The original unknown assailant was a black male wearing a gray hoodie and blue sweatpants, and also had a goatee and short hair. Ooh, more descriptive this time. The suspect was possibly wearing Centennial High School attire, as he believed he was a student there for a sporting event. This all took place on the visitor side of the stadium, and the victim was under the Memorial High School tent in the bleachers. Around the same time, school resource officer Cortez arrived at the scene and began assisting the victim, trainers, and other parties. Officer Cortez also advised on the radio he had the suspect. Sergeant Otis, he's talking about himself in the third person now? Okay. This Sergeant Otis here would like to talk about himself in the third person. Sergeant Otis was working the 50s sector as the sergeant. Well, presumably, I mean, He was in full Frisco Police Department uniform with distinct patches and badge and a police duty belt. He was also marked in the Frisco Police Department patrol vehicle. He was relatively close to the call. Reading this in the third person is weird. He was relatively close to the call and placed himself on it in around 10 o'clock in the morning and responded to the call with his patrol vehicle overhead lights and sirens. He arrived at the scene approximately 4 minutes later. Sergeant Otis arrived at the stadium and began walking up to the location. At around this time, Officer Cortez and Officer Ritchie were walking a black male suspect away from the stadium. The suspect was crying hysterically. Please see other involved narratives for their involvement. Sergeant Otis walked up to the visitor bleachers and observed the victim being treated by Frisco Fire Department personnel and also athletic trainers. The weather began to turn and it began to heavily downpour rain. At this time, some of the FISD staff moved the memorial tent to cover the victim, and FFD personnel, Sergeant Otis, began using his city-issued phone to snap crime scene photos to preserve as much of the scene as possible due to weather and large gathering of people that were involved. I mean, that sounds like a pretty reasonable procedure. Are you trying to tell me these police officers took pictures of the body? Like where it was? They took pictures of the body and tried to take pictures of the scene and tried to capture the scene and the body and tried to capture images. Are you trying to tell me they used their photographs to capture images of the scene? Wow. Amazing. What a novel idea. What a novel idea. Geez, the weather's changing. That could change the crime scene. Maybe I should take some photos real fast to try to preserve the crime scene as much as possible. Maybe that would be a good thing to do. What a reasonable approach. Other officers began setting up crime scene with tape, moving non-essential personnel to the immediate area. The officers on scene were informed that the knife that was used was tossed and was still believed to be somewhere close. Eventually, one of the witnesses said they remembered seeing it on the bleacher still. Officer Chalez was able to locate the knife. Hala Chalez. It was located between rows 9 and 10 near seat 30, closest to the aisle partially open. Wait a second. You mean you documented exactly where you found the knife? You documented where you found it? You actually took a note and be like, I found the things at this place. Wow. I mean, if only we could do that with taillight pieces. If only they'd be like, wow, we found the taillight pieces in this, only if we these people believe in documenting things. How nice. How very nice. Oh, this is where I found the knife. Oh, that's helpful. Thank you for clarifying that information. The rain began to come down heavily and was determined that instead of moving the knife, officers would cover it with a blue tarp. Well, that's reasonable too, right? I mean, rather than moving the knife, because that's not necessarily ideal. I want to preserve it. And so, but geez, it's raining a lot. What could I do? Maybe I could cover it with a tarp and then the rain wouldn't get to it and that would help preserve the crime scene. Sergeant Otis assisted in preserving the immediate crime scene as much as possible, while the other personnel tended the victim and eventually transport him. At around this time, Officer Wenzel had the crime scene log. Wait a second, these guys have a crime scene log? Who gave these guys crime scene log technology? At around the same time, Officer Wenzel had a crime scene log and it began logging the individuals on the call to his best of ability. Lieutenant Crawford and Pembleton relieved Sergeant Otis on the scene. Sergeant Otis went back to the police department to download his body cam and photos he took. He's preserving evidence right away? Sergeant Otis' city-issued phone had a total of 33 photos that were used to document the scene. During the download, the initial photos formatting was incompatible with the crime scene photo. He re-downloaded the photos he took, and they were able to be saved properly for preservation of evidence. Holy shit. Holy shit. These guys are like reasonable and thinking and doing stuff in a reasonable thinking way. Wow. How neat. We have further statements. Officer Wenzel would like to offer his thoughts on the matter. On Wednesday, April 2nd, 2025, I, Officer Wenzel, was assigned to work patrol in the city of Frisco. At approximately 10 in the morning, I responded to a report of a stabbing at the stadium. The original note stated an athlete had been stabbed in the chest and the suspect that the stabbing the victim goes to Sentinel High School. Athletic trainers were on site and providing care to the victim, and it was advised he was not conscious and not breathing. The notes also indicated the suspect was a black male with a goatee and short hair wearing Sentinel gear. So they all have slightly different memories of what exactly they were told, but they're all consistent. Like one guy's like, oh, I just knew that he was in sweatpants. One guy's like, oh, I remember goatee. One guy's like, no, I was told it was Sentinel gear. It's like, yeah, but it's like, but they're different people. So they kind of remember different details as one would expect, but they're all consistent because they're not incompetent. I arrived at the scene approximately 4 minutes later. When I arrived at the scene, I grabbed a roll of crime scene tape and proceeded to the victim's bleachers where dispatch advised where the victim was. While I was walking towards the visitor bleachers, I was approached by a witness. The witness began telling me what happened, and I asked him where the stabbing occurred. I advised it happened under the Memorial High School pop-up tent in the visitor bleachers. I immediately informed Sergeant Otis where the witness stated the stabbing had occurred and gave him crime scene tape to start securing the scene. Nice. Sounds almost like proper procedure. This is not going to stop being funny for a while, guys. I'm sorry. I then had someone move to the walkway under the visitors' bleachers out of the rain to further speak with me. So the witness, I had to move somewhere so we could have a conversation not in the rain. Neat. The following is a summary of my contact with the witness. Okay, great. The witness advised me he was sitting under the Memorial High School pop-up tent with his team and was near the victim, Austin, and the suspect, who was later identified as Karmelo Anthony. Anthony was from Sentinel High School and was sitting under the Memorial High School tent. Austin had told Anthony he needed to move out from under the team's tent, and Anthony grabbed his bag, opened it, and reached inside and proceeded to tell Austin, touch me and see what happens. No one really thought Anthony really had any weapons in his bag. Even if they had, incidentally, it doesn't really change the legal analysis, incidentally, but whatever. No one really thought that he had any weapons in his bag. And Austin proceeded to touch Anthony, and then Anthony told Austin to punch him and see what happens. Okay. A short time later, Austin grabbed Anthony to tell him to move, and Anthony pulled out what the witness recalled as being a black knife and stabbed Austin once in the chest and then ran away. Yeah, that self-defense and imperfect self-defense case is not looking really solid. His imperfect self-defense is looking very, very shaky based on this recollection. Not a lot of high hopes here for our friend. Not looking great. Austin began grabbing his chest and telling everyone to get help. So the witness advised he did not know Anthony's name, but stated another Memorial track member was friends with Anthony and he could identify Anthony. The witness described Anthony as a black male, skinny, with a possible goatee, short puffy hair, and wearing Sentinel High School clothing. This concluded my contact with the witness. I was then instructed to start a crime scene log. Wow. I retrieved a crime scene log from my patrol vehicle and began starting the crime scene log. I was later relieved by Officer Chalez, who took over the log, and I cleared the scene. Neat. Officer Hancock would like to add his thoughts to the equation. Today, April 2nd, 2025, we're working as a school resource officer at Independent High School. A weapons call was dispatched over the air that detailed a stabbing that occurred at the stadium. After hearing more dispatch call information, I drove to the scene. While en route, I heard Officer Cortez say that he had a suspect in custody. When I got on the scene, I looked for Officer Cortez and went straight to him to hold security with the suspect that he had cuffed and secure in the police squad. Multiple witnesses were providing statements to officers where the stabbing occurred at the Memorial High School track tent. Only a short time later, Officer Cortez and myself escorted the suspect, Karmelo Anthony, to the Frisco Adult Holding Facility. Anthony was transitioned off to the jail cell without incident. All jail paperwork was completed and CID took over the investigation. Officer Fisher would like to add his thoughts to the mix. On Wednesday, April 2nd at around 10:05, Officer Fisher was dispatched to the stadium in regards to a stabbing. The note stated that an athlete had been stabbed in the chest, was unconscious and not breathing. When I arrived, the crime scene was already marked off and the suspect was in custody. I began asking people if they were witnessed anything. I made contact with a witness, and then another witness. They were both breathing heavily and crying due to the nature of the events. They were with their coaches on the field and it was pouring down rain. We made the decision to relocate to the locker room just to the east to get out of the rain. Once there, things calmed down a little bit. However, they were still hysterical, could not really talk. In there, I learned that Hunter was the brother of the victim. I attempted to ask them both about what happened. I really couldn't get anything out of Hunter, but another witness stated they wanted to speak. I asked him what happened, and he stated they were all sitting on the bleachers under a Memorial High School tent, when another male, who he did not know, walked over and sat under the tent. The witness then stated that Austin, the victim, told the male since he didn't go to Memorial, he had to leave the tent. Austin and the male went back and forth, and then Austin stood up and pushed the male to get him out of the tent. The witness had said at the time of the arguing, the male was reaching around the bag he had. It was at this time the male took out a knife and stabbed Austin and left the scene. This is all of what I remember the witness said to me. After this, I then stood with three athlete witnesses until CID interviewed them. I then was relieved and went back on patrol. Okay. Officer Crawford would like to add their equation to the mix. At April the 2nd, at approximately 10 o'clock, I, Lieutenant Crawford, was dispatched to the stadium in reference to a stabbing. I arrived on the scene and observed medical personnel and several bystanders standing near the subject, later identifying the victim, Austin. The medical personnel was actively engaged in life-saving measures with presumably the victim. I then observed a crime scene was created around the area and began collecting names and contact information of bystanders. You recorded the name of witnesses? Wow. I then met with Officer Wenzel and directed him to begin a crime scene log. As I was getting the needed paperwork, I took over his responsibilities of monitoring a witness to the event. Ultimately, the witness was taken to another area out of the rain, and Officer Shells took over the crime scene log, and I forwarded information about the bystanders to him. From that point forward, I was a coordinating response with the school resource officer and a bunch of other people. I took no other action at the scene. My body-worn camera did not activate when I arrived at the scene, but I did activate it when it discovered it wasn't recording while waiting for a witness, and I have nothing further to say about the issue. Cool. Officer Shallows would like to offer their equation to the mix. On Wednesday, April 2nd, I, Officer Shallows, was working as a school resource officer at the Student Opportunity Center. At approximately 10 o'clock, I was dispatched to the stabbing that had occurred at the stadium. It should be noted that my location is approximately 200 yards from the stadium. Upon my arrival, I tried to get an updated location of the suspect. I could not see Officer Cortez when I arrived. Officer Cortez informed over the radio that they had the suspect in custody. At this time, I turned my attention to the victim. Multiple trainers were already performing CPR. I could see blood on and around the victim. At this time, medics arrived and began life-saving measures. I coordinated with other officers on the scene to secure the location. By the time the students and staff had cleared the area, I used crime scene tape and began to tape off the area. It began to rain harder at this time. Sergeant Otis and myself moved a Memorial High School tent over the medics and the victim to attempt to preserve evidence. Yeah, I mean, hey, wow, it's like, hey, this victim is out in the rain, and well, there might be evidence. Hey, I can't help noticing that there's this tent right over here. What if we took the tent and we like moved it so it would like cover the body and help to preserve the scene as much as possible? That sounds like a good idea. Maybe we should do that. What a reasonable approach these officers have. Competency is nice. A memorial coach approached over the medics and victims to attempt to preserve a memorial coach approached me and informed me that he's with a student who claimed to see the altercation. I told the coach to stick with the student and we would need to get him to the police station to give a statement. The student quickly informed me that he knew where the suspect threw the knife and pointed to its location. I located the knife with Sergeant Otis and could see blood on the knife. I quickly used my city-issued phone to take pictures before rain could wash the blood away. Wow, you tried to take photos to preserve the murder weapon before taking it away. Wow, that's an interesting idea. So your thought was, geez, maybe I should take photographs of the murder weapon where it lay. Maybe I should preserve what the murder weapon looked like before I take it to the police station with my cameras. Maybe if I took photographs of the thing in its most pristine state that's possible, closest to time, maybe if I took photographs, that would help some way in the investigation and would document the condition of the knife before it was taken to the police station. What a fun idea that might be. Taking photographs of the murder weapon before you take it away. What a deep and exciting thought. Sergeant Otis located a blue tarp and we decided we should cover the knife without touching it and attempt to preserve evidence. What a thoughtful idea. Sergeant Otis located blue tarp. Okay, it was windy and raining hard. Once we positioned the tarp over the knife, I reached down and grabbed a backpack left in the stands to weigh the tarp down and threw it up by where Sergeant Otis was positioning the tarp. It was later discovered the backpack I threw onto the tarp was the suspect's backpack. It was the only Sentinel High School backpack located within all the backpacks in the areas of the stands. After securing the scene with crime scene tape and attempting to preserve as much evidence as possible, I assisted other officers with locating potential witnesses. Officer Wetzel was maintaining scene security while I was assisting other officers. After medics transported the victim, I relieved him of that post so he could go back on patrol. I maintained scene security until the call was cleared. Photos will be uploaded to the crime scene photo and my body cam will be downloaded at the end of my shift. Excellent. Excellent. These are all very good plans. Officer Pemberton would like to offer some thoughts. On April 2nd at around 10 o'clock, 10:04, I, Lieutenant Pemberton, responded to this scene in response to a stabbing. The location is the school stadium. Call notes advised the male had been stabbed and was unconscious. Upon arrival, several officers and medical personnel were attending to the victim, who was laying on the ground at the stadium bleachers. I coordinated the Frisco PD response and tried to establish the crime scene. The knife reported to have been used in the assault was located by another officer in the bleachers. Shortly thereafter, a large downpour of rain began. I directed several officers to use a tarp found at the scene to cover the location of the knife. I remained on scene until the victim was transported and the crime scene was established. Guys, it's not that hard. It's not that hard. I mean, it's pretty basic. Anyone want to tell Canton? Officer Newton offers some opinions. On April the 2nd, I responded to Texas Health Plano to assist with the case. I was tasked with meeting the ambulance at the hospital. I arrived prior to the ambulance and wait for them to arrive. They arrived at 10:46 hours with the victim, who was brought into trauma bay for treatment. At 10:53 hours, Dr. Chow pronounced Austin deceased. Once he was pronounced, staff stopped treatment and disconnected cords and tubes from the machines without removing anything from the body itself. While on scene, I took possession of clothing worn by Austin and maintained possession of the items until crime scene took them from me. You tried to preserve the victim's clothing? You tried to preserve the victim's clothing so that it could be maintained, again, ideally as close to its original state as possible, given what else was going on? I mean, he was transported to the hospital and, there was life-saving measures done. So it's not exactly the same, but you basically did your best. You did your best to preserve the victim's clothing as close as was possible, given other things that needed to be dealt with, and took efforts to secure the clothing and preserve it. Neat. You made sure that the crime scene would be able to get it in its most preservable state possible. That's also neat. While on scene, Officer Landon requested assistance in lifting sheets off the body to take photos. I then placed sheets when complete. Oh, so you decided to take some photos of the body while it was in the emergency room. That's probably a good idea, for preservation of evidence and also comparative photos and all. That sounds like a pretty reasonable thing to do. Okay, good work. Yeah, that sounds good. At one point, they rolled the body and removed shorts from Austin, which were bagged and stayed in my custody until CSI took them. You mean you didn't leave them in a trunk for the next month? You didn't preserve the clothing and then just let them roll around in your trunk for 30 days? You didn't do that? You preserved them and then transferred them to the crime scene tech immediately? And also, incidentally, who you transferred them to, because you took a record of who you gave them to. So who took possession from you. That's fun. I am. At 13:24 hours, family was allowed in the scene to view the body. I was informed by staff and officers they'd be allowed to touch the head and feet, which they did. At 13:37, nurses from the officer bagged him in a body bag. At 15:50, transport service for the medical examiner took possession of the body. A tag was placed on the body and secured. I took notes during this time, which were scanned into the report and booked as evidence. I turned in the crime scene log to be scanned into the report. You also had a crime scene log? You had a separate crime scene log? You also were maintaining a log in a crime scene log? Who gave these officers crime scene log technology? You guys have logs over there? At the conclusion of the call, I took off my camera off covert mode and went to turn it off. At that point, I learned the camera had failed to activate. Due to it being on covert mode, I did not see the light indicator on top of the camera. So my body camera wasn't working, which, okay. But, I did other things. Sorry, the body camera wasn't working. Sorry about that. But, I took notes and stuff and I took some photos and, I had a crime scene log and stuff. So, pretty good work, officer. Not bad. Officer Higgins says the following. On April the 2nd, I, Officer Higgins, was working as a desk officer at 7200 Stonebrook Parkway. At approximately 10:42, someone walked into the main lobby stating they witnessed. Okay, so this guy's working the police station. And told to come into the lobby to complete a witness statement. I gave the witness a voluntary witness statement, which he worked on until detectives arrived to speak with him. Having left with the detectives, I returned my normal duties. Neat. A person comes in the police station, says, I'm a witness. Cool. Here's a thing. Please write down what you observed if you don't mind. Also, I'm going to call some detectives to speak with you. What a nice idea. Officer Craig. On Tuesday, April 2nd, at approximately 10:01, I, Officer Craig, the school resource officer for Liberty High School, was at Heritage High School and heard via radio that an FISD student had been stabbed at the stadium. I immediately responded. Upon arrival, I made contact with Officer Cortez, who was standing next to a marked police vehicle. Officer Cortez advised he had detained the suspect and was in the patrol vehicle. I then responded to the victim scene that was in the north bleachers. As I walked up, I noticed Frisco Fire Department personnel were attempting to provide life-saving measures to the suspect, later identified as Memorial High School student Austin. As other officers were working the scene, I was asked to respond to the stadium's media locker room and keep the following statements witnesses separate until detectives could speak. You tried to keep the witnesses separate from each other? You tried to keep the witnesses separate from each other so their recollections would be as independent as possible? Is that what you're telling me? You tried to keep the witnesses separate so that their statements would be as independent as possible? Interesting. Good idea. That's a pretty good idea. Sounds like a pretty reasonable approach. Probably should do that. While I was with them, I was told to take their cell phones from them and later turn them over to Sergeant Bissonnette. After being relieved, I was asked to make contact with all the FISD athletes that had been placed on school buses. Below is a list of students who identified themselves as witnesses. And here's all the potential witnesses we have. So it's like, oh, I went to the school bus. And like, hey, did anyone observe the crime? I did. Cool. What are your names? Here are their names. Great. We have a long, long list of potential witnesses. Exciting and fun. I also met with the following coaches who advised they observed the incident. After completing the task, I cleared the scene. Sergeant Alves says, on April the 2nd, I, Sergeant Alves, responded to a stabbing. Upon arrival, I provided the scene security and assisted with keeping civilians away from the crime scene. I maintained this position until I was relieved and cleared the scene. Officer Miller. On April the 2nd of 2025, at approximately 10 o'clock, I, Sergeant Miller, was dispatched to the stabbing location located at the stadium. Call notes stated that one student was stabbed in the chest by another student. Upon arrival at my location, my only duty was to provide scene security. As the Frisco medic was leaving this location, I assisted in moving people out of the way for the medic to be able to drive through. Shortly thereafter, I cleared the scene and nothing further. Okay, so we now have some primary information from the government. Not necessarily complete, but at least it's primary. It's a start. And so things are not necessarily looking really promising for our defendant friend. You know, it appears based on the statements that we do have, what we're talking about is a battery, but, you know, in technical sense, by the victim, that he was, it seems like, trying to push him out of the way with, you know, a fairly moderate amount of force. It doesn't seem like, you know, it was more than that. It doesn't seem to be the level of force that would imply deadly force. It seems to be, at least the way it's characterized, much, much less than that. So our self-defense claim is not looking really, really solid right about now. And our imperfect self-defense claim is going to be challenging at best, based on what we know. Because the jury has to buy it, right? The jury has to buy the imperfect self-defense claim. So they have to buy that even though, strictly speaking, it was not justified, it was kind of a little bit justified. And I think they're going to have a problem with that based on this fact pattern. You know, it would help the defense if, you know, it would help the defense if it was more aggressive than is indicated. It would help the defense if there were more people involved than just the one person. It would help the defense if the person had a strong reputation for just being like a bully who beats up people all the time, and the defendant knew that. If he knew that, that'd be nice. But short of those things are not looking really promising for his future relating to this charge. So, yeah. He has two of the top civil rights lawyers. Cool. Good luck. Good luck. He doesn't need a civil rights lawyer right now. He needs a criminal lawyer. Yeah. So good luck on that. I'm not seeing it right now in the fact pattern, but, you know, good luck. Based upon Texas law, we have a jury instruction he cannot claim self-defense. In response to non-deadly force, I don't know if that's true or not. I was under the impression that Texas allows for imperfect self-defense. Is that not true? If Texas does not allow for imperfect self-defense, because not all states do. If Texas doesn't allow for imperfect self-defense, then, you know, then this entire discussion is moot if I made a mistake. But I thought they did. Let's see if I can find out. All right, so I want to search Texas courts. Let's see. Imperfect self-defense. Right. Yeah. So yeah, the imperfect self-defense. Yeah. So yeah, Texas definitely has it. So I wasn't wrong. We can go to a couple cases here. Just pull up two from the Texas Court of Criminal Appeals real fast. Yeah. The Texas Court of Criminal Appeals is the highest court for criminal law in Texas. I had to double check because I always get confused. But yeah, this is the Supreme Court for criminal issues. So like here's one, for example, from 1980 on this kind of issue. Yeah. So hold on. I'll just search for imperfect because it'll give me a more precise. Yeah. 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 As is the practice under prior law, the proper approach when the issue of imperfect self-defense is raised is to give an instruction on self-defense, but also give a limiting instruction. The limiting and independent instruction is commonly referred to as provocation. Essentially, the jury is instructed that if they find the defendant provoked the difficulty, then they forfeit the right of self-defense, which is true. So yeah, Texas does recognize imperfect self-defense. And he makes the burden of production because the burden of production is literally anything. All right. So to offer the defense, he has to make the burden of production, but he was touched and that qualifies. So he makes his burden of production. Whether he can convince a jury of that, who knows? And whether or not he provoked it, still yet to be decided. I'm not sure that he provoked it in a legal sense, but but you know, there could be fights over that. So for the moment, I'm assuming that he did not provoke I'm assuming the guy with the knife did not provoke it legally. I assume there might be a fight over that, but I'm going to assume it's not true for the moment, because yeah, that's how I think imperfect self-defense might be available. So yeah, shocked the chat was wrong. Yeah, I know, right? I thought they would be wrong. Yeah. Yeah. And here's another one talking about provocation. This is also from the Supreme Court of Texas Court of Criminal Appeals. So it's the same thing. That's the highest court in Texas for criminal appeals. Here's something on relating to evidence required to raise provocation. If read literally, the issue would only apply to circumstance where the offense is really voluntary manslaughter rather than capital murder. Indeed, the requirement that the killing be reasonable is a more difficult requirement to meet than for reduction to manslaughter. It appears, therefore, the question ought to be submitted even in circumstances where conduct is marginal in its reasonableness. Right? So yeah, this seems like a jury question, right? The question should be submitted even where it's very marginal. Thus, imperfect self-defense issue, even if so imperfect, it would not justify reduction to manslaughter, should be considered to raise the issue and require provocation to be submitted. So, like, again, like, yeah, it doesn't take very much to offer the defense. So he makes his burden, assuming that the guy with the knife is not the provoker, which is the assumption I'm going with for the moment, then he has the ability to offer the defense. But of course, the jury has to buy it. Just because he can offer it doesn't mean the jury has to buy it. It's a possible defense, not necessarily a successful one. And so, like, you know, and that's going to be and I would imagine, although I wouldn't know for sure, that it's going to be based on a whole number of factors, not the least of which is the relative proportionality. So the more violent the non-deadly force. The more violent the non-deadly force, the more likely the jury, I would think, would be likely to buy it as a mitigating factor that might justify a manslaughter conviction. And the less so, the less so. That seems plausible. So, right now, however, based on the information we presently have available, it looks pretty disproportionate, right? It doesn't look like it's particularly violent in a meaningful sense. So, in sort of that balance on the equation, it doesn't look like it's going to be likely to be particularly successful based on what we know at the moment. But he does make his burden of production, so he can offer it, and good luck. Yeah, I mean, whether or not he was provoking, maybe we don't have enough information, and obviously everything can change. So at least in my mind, I don't necessarily I just said the same thing 5 times. I'm sorry. I got tripped up. I don't necessarily consider myself the expert on what necessarily qualifies as provocation. So I'm certainly willing to hear other opinions on this issue. But I'm going to assume it's not true for the moment. If for no other reason, then by assuming it's not true, I therefore provide the best possible case for the defendant, right? As sort of forecasting the odds. So by assuming that it's not legally provocation, because if I assumed legal provocation, then this entire discussion just becomes moot, and it's murder. So in some senses, the safer thing for me to do is to assume it's not, because by assuming it's not, I leave open the possibility, and therefore I leave open the percentage chance, as opposed to foreclosing it. So probably the safer thing for me to do is to assume it's not provocation, and go on that assumption. So I think that's the reasonable approach right now. Yeah, as to bringing the knife to the scene, I don't think that's relevant. We've discussed that before. He might be guilty of something else, but him bringing the knife alone is irrelevant. Yeah, it doesn't matter. I mean, yeah, it doesn't matter by itself that he brought the knife. It doesn't matter to the self-defense claim, to be more specific. It might matter to some other claim, but it doesn't matter to the self-defense claim. Is touch me and see what happens provocation? I don't think it is. I don't know. I'm sure that there will be an interesting issue on the issue of whether touch me and see what happens is provocation. I don't know if that's provocation. I'm going to assume it's not for the moment. But I don't consider myself the foremost expert on what qualifies as provocation. So if there's another commentator out there who is more educated on this particular aspect, I'd be willing to defer to a more educated opinion on this specific aspect of law. Yeah, these pleas definitely sound too smart. I agree with that for sure. Thank you, Jefferson, for that nice super chat. Singing another team's tent is not provocation. Is it provocation for a fight? That's like, is it provoking the fight? I don't know. Yeah, I'm gonna go for what it's worth. Bronca thinks it's provocation. Bronca might be right. That's provocation. That's a fair opinion. I'm gonna go with no for the moment, though. Not supposed to be in the tent is not provocation for the fight. Yeah, I'm not sure that qualifies as provocation. provocation at its core is I'm trying to instigate the fight. My provocation is the intent to start the fight. I'm trying to start the fight, essentially to give myself an excuse to self-defense. So because of my bad motives, I'm not protected by self-defense because I was trying to start it. I was trying to start something in order to give myself an excuse. And you can't do that. You can't start something in order to give yourself an excuse. So the provocation has to be in the nature of the provoking the fight. So that's my best opinion. Hit me as provocation. That's a fair point. Hit me and see what happens. Maybe. Is hit me and see what happens provocation? It might be. It might be. It'll be an interesting issue, I'm sure, on some judge someday is going to have to make this decision. If I were a betting man right now, I would be. If I were a betting man, I think I'd bet on balance the judge would likely let the issue go to the jury rather than deciding it, themselves. But there's definitely going to be some fights over it. I imagine. Yeah, sounds like he shoved him. That sounds like it, yeah. Sounds like a shove based on it. This will be pled out. It might well be pled out still. That's not beyond the possibility. A plea deal is definitely possible. It's not going to happen anytime in the relatively near future. The investigation isn't even over yet. There's way more information that has to be discovered. The police investigation isn't even over yet. So it's way too premature for a plea deal, but a plea deal is definitely possible depending on, what is developed and a whole bunch of other factors. Can I fix Lori Vallow? I don't think so. I think she's beyond help. What happened to my left eye? Nothing happened to my left eye. It's just a little bit. It's age. Age happened. Thank you. Also, that was impolite. You shouldn't have asked that question. You're getting a timeout. Think about what you did. Was it raining heavy that day? It appears to be raining in spots. It appears to be like raining and then not raining, raining and then not raining, as sometimes happens. Plea deal may not happen because of public pressure. Yeah, it's way too premature to answer that question. Why, if I ask why the other eye looks normal? Okay, you get a timeout because we have a failure to learn. Anything else? All right, guys. Well, I guess I'm going to go ahead and sign off for now. I hope you've enjoyed this stream. We'll see as more develops. Obviously, if a video comes out about the incident, that would help a lot in trying to figure out exactly what's going on. That would provide a lot more information. It's hard to believe no one videotaped this and haven't uploaded to social media. So yeah, 1 or 2 years before this gets a court date, that sounds very, very plausible. Yeah, that sounds very, very likely. What are my thoughts on it being brandishing while the hand's in the bag? I don't think that qualifies as brandishing. Brandishing, you have to expose it. So unless he said, I have a knife, I don't think that qualifies as brandishing. Yeah, no. What else should we stream about today? What else is happening in the news that we could stream about? Anyone have any ideas for a later stream? I need a little break, but we could stream about something else. Is there anything else in the news we could stream about that looks interesting? Did I say he has self-defense? I said he has the possibility of an imperfect self-defense. He has a possibility of imperfect self-defense. It's not great, but he has the possibility based on the information that's available. And if his imperfect self-defense is successful, it would cause the charge to be dropped to manslaughter, which is a 2 to 20. So that right now appears to be the best scenario. The best scenario for him right now is that he has a plausible self-defense, a plausible imperfect self-defense claim seems to be the best scenario, and that would be a 2 to 20. So, yeah. Scottus on not hiring probation employees. I might do that one. Yeah, the mayor with the noose on the neck. I tried to do an edited story about that, and for some reason I just wasn't able to put it together. But it was hilarious. I really should give another shot at trying to put that story together as an edited story. Yeah, I already covered the immigration story. I haven't covered the probation fed workers. But the probation fed workers wasn't a decision. They just removed a stay or something. Yeah, the Supreme Court just like removed a stay. It was an unsigned order. Yeah, it was just a removal of there's really not much to discuss in the federal worker thing. He'll have to admit to knife possession for self-defense. Oh, he will. Yeah. He will admit to it, I would imagine, because that is the least of his problems. Yeah, the knife possession is the least of his problems. So I would. I might be admitting to having a knife on school grounds, but that is not my immediate problem. All right. Well, I'm going to sign off for now. I've enjoyed our time together, and I hope you've also enjoyed our time together. I've been on Civil Law. Until later, my friends, I hope all's well for now. My friends, cheers and goodbye. If the blade is over 5.5, he forfeits self-defense. There is no way that's true. There is no way that if the blade is over 5.5, that he forfeits self-defense. There is no way that that's true. Where did you get that statement? Look it up. Okay, look it up where? Give me a citation. I'll look it up. Give me a citation. I'll look it up. Tell me. Oh, wait. He forfeits self-defense because there's law against confronting someone with a weapon. Well, even assuming that that's true, it wouldn't be because the knife is over 5.5. So, one goalpost at a time. The claim was he forfeits his right of self-defense because the knife is over 5.5. That was the claim. All right. So, can you back up that claim? What citation are you referring to in order to back that claim? Or would you like to withdraw your stupid? Because it's wrong. An individual can carry a knife concealed provided the blade is not longer than 5.5 inches. Okay. So you're trying to argue that his carrying of the knife was illegal. Okay. And assume that his carrying of the knife was illegal, which is pretty easy because he was on school grounds. Why is the fact that his possession of the knife was illegal prevent him from using self-defense? Branca mentioned it. Okay, well, it's your claim, so I want you to support the claim. Kirkendall, I'll try to remember that, but there's no way I'm going to remember. Yeah, name pronunciation and I don't necessarily always get along. It's one of my charms. Minors are allowed to carry a knife longer than 5'5" only in specific circumstances. Okay, assume that him carrying the knife was illegal. He loses self-defense because his carrying of the knife was illegal? I don't think so. Yeah, I don't think so. I don't think even if his possession of the knife was illegal, he doesn't lose his claim to self-defense. So your claim is based on an erroneous presumption. Your claim is based on the presumption that if the knife was illegal, he loses his claim to self-defense. No, he doesn't. Why? What? Yeah. So, would you like to withdraw that now, or what? It's KURT. I never said he lost the right to self-defense. Well, the claim was specifically, once again, the claim we've been discussing was that because the knife was over 5'5", he lost his claim to self-defense. That was the claim. Because the knife was over 5'5", he lost his self-defense claim. That was the claim. That's the claim I've been addressing. So if your basis for saying because it's over 5'5", he loses claim of self-defense, if your basis for that is his possession of the knife was illegal, it's like, okay, assume the knife was illegal. Why does he lose his claim to self-defense then? So I'm still back to the claim I was rebutting. The claim was because the knife was over 5'5", he loses his claim of self-defense. So back the claim. Because he was not where he's supposed to be, he could be barred from self-defense. Okay, fair enough. Let's take a look. Let's take a look at the statute and see. Let's take a look. And incidentally, by the way, I'd just like to note for the record before we look it up, that's still a different argument. I'd like to note for the record, you are switching the goalposts. Because once again, the claim was specifically because the knife was over 5'5", he lost his claim of self-defense. Now you're making a different claim. Now you're making the claim because he wasn't where he was supposed to be, he lost his claim of self-defense. So I'd just like to note for the record that you've changed claims. Okay? Bearing in mind. Let's take a look at 931 and 932 and see if it opines on this subject. That's not my claim. I mentioned trespassing or any crime. Well, it was the claim I was responding to. That's the context of the claim. So that's the claim I've been addressing this entire time. So I'm assuming that any chat you give me is responsive to the claim we're addressing. Otherwise, you're off topic. I was addressing a very specific claim. Because the knife was over 5'5", he loses his right of self-defense. That's been the conversation the entire time. And then I noted that you shifted the goalposts of the discussion. And then you're like, it's not my claim, but it's the claim we were discussing. So I'm noting that the claim has shifted because it was the claim we were discussing. Okay. Yeah, it's illegal to carry a pocket knife on school grounds. Yeah, I understand. I understand. All right, let's take a look at 931 and 932 and see if it offers anything to opine on this issue. All right, 931 self-defense. Except as provided in subsection B, a person is justified in using force against another when and to the degree the actor reasonably believes force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. The actor's belief the force was immediately necessary is described by the subsection is presumed to be reasonable if. Okay, and then it goes through a whole bunch of things that will presume it, but we don't have to do that. The use of force against another is not justified if, in response to verbal provocation alone. Well, it wasn't verbal provocation alone, so no. To resist an arrest or search the actor knows being made by a peace officer doesn't apply. If the actor consents to the exact force used or attempted by the other, doesn't appear to be complied. If the actor provoked the other one, I don't think this legally provokes. So I don't think that applies, so I'm going to skip it. If the actor sought explanation from or discussion with the other person concerning the actor's differences, That's not what happened. So none of those things apply. So none of Section B applies to this situation. Okay. So yeah, none of those things apply. And then 932, deadly force. A person is justified in using deadly force against another if the actor would be justified in using the force against another under a different subsection, and whether and to the degree the actor reasonably believes deadly force is necessary to protect the actor against others' use of deadly force or prevent a forcible felony. Yeah, so I mean, that doesn't work, right? So that doesn't work. The officer's belief under subsection A2, deadly force was immediately necessary, is presumed to be reasonable if a whole bunch of things, which we don't have to read. A person who has the right to be present at a location where deadly force is used, who has not provoked the person, has not engaged, is not required to retreat. So, none of these things appear to apply to that situation. So his mere fact of his illegal presence doesn't appear to apply, or the mere fact that his presence was not proper does not appear to remove him of self-defense based on my reading of the statute, unless I'm misreading something. So it doesn't appear to apply. Should we just watch Law Self-Defense's take and critique that? We could do that. We could do a stream snipe and just respond to his take. We haven't done one of those in a damn long time. Is it illegal to defend yourself with a prohibited item? No. No. The mere fact that the item is illegal does not defeat the self-defense claim. Yeah, it does not defeat the self-defense claim. Has to do with castle doctrine. It's hard to believe that castle doctrine applies in this situation because we're not in a person's home. So I don't think castle doctrine is the thing. I seriously doubt that's the issue. All right, let's watch Law of Self-Defense and see if he provides some thoughts on the subject. Don't you always have a right to self-defense? Well, no, not necessarily. You can lose the right to self-defense through, provocation and other things. So no. You don't necessarily always have the right to self-defense. All right, so let's watch Branca's stream or Branca's discussion of it and see what he thinks. And, Branca is a self-defense expert. So, I mean, I'll credit him that. Although not necessarily in Texas specifically, but he certainly has broader knowledge about the subject at large. So, fair enough. A person committing a burglary or robbery cannot claim self-defense? Yeah, but we don't really have any facts to support that at this time. So even assuming that that's true, we don't have facts to support it. So it's not worthy of discussion. We have no facts to support a burglary or robbery. If we did, we'd have a different discussion. Yeah, if the person themselves is committing the forcible felony, then yeah, that, fair enough. But that's not where we are. Let's take a look. With a proof he was trespassing and asked to leave. I don't think that does it by itself. It isn't someone's home, so I don't think mere trespass works. Yeah, mere trespass doesn't seem to work because, if I'm trespassing on a business, they can't use lethal force. They can use non-deadly force to eject me, but they can't use deadly force to eject me. And also, it has to be done by somebody who is an agent of the property or, empowered by the property. It just can't be just anybody. So the students aren't an agent. And, I don't think that works. It was not reasonable or proportional. No, I probably was not. It probably was not reasonable or proportional. I haven't said anything different to that. I've already said on multiple occasions that his defense is based on the information we have, does not appear likely to be successful. So you're not contradicting me. I don't know if you think you are, but you're not. If you trespass on someone else's property, you can't get self-defense generally against persons authorized to be there. I don't know if that's true. All right, so we're doing this 1 day ago, or are we doing which video are we doing? We're doing the one 2 hours ago from the law of self-defense, or are we doing the one from like a day ago or something? Which Branca video should we watch? If someone's on my property, I tell them to leave and they don't, can I use no lethal force? You can't use lethal force to eject someone from property, generally speaking, no. Do the most recent? Okay, we'll do most recent.
Welcome, everybody, to another episode of the Law of Self-Defense. Here to talk about the tragic stabbing in Frisco, Texas that occurred at a track meet just about a week ago today. And we have
I'm going to speed it up a little bit
because the police report over the stabbing has been released. I did cover the stabbing initially on Saturday. It occurred last Wednesday. But of course, on Saturday, we had rather limited information, kind of the chaos of war happening. Now we have an actual police report to take a look at, and that's what we'll be doing.
Texas Penal Code 931B1. Self-defense is the area where self-defense is barred when committing a crime. Let's take a look. Texas Penal Code 931B1. 931B1. No, you're citing the wrong provision. Yeah, 931B1, I don't think so. This is section 931. This is section B. This is section 1. Section 1 deals with verbal provocation. It has nothing to do with the area of self-defense. Your citation is incorrect. Would you like to try again? Would you like to try again?
Today, doing a use of force legal analysis of this event based on those additional facts and, of course, Texas law on this case. So, as I said last Wednesday, 17-year-old Karmelo Anthony, 17-year-old young black man, fatally stabbed Austin Metcalf, also 17 years old, happened to be white. Both of them were attending a Texas high school track meet. Both the 17-year-olds were in high school, but in different high schools. Karmelo Anthony, the stabber, quickly fled the scene, discarded the knife he'd used in nearby bleachers. He was shortly captured and arrested, conceded to the stabbing immediately upon contact with police.
What about Section A, carrying a weapon in violation of 4602? Let's take a look. Section A. You're talking about 931A? 931A has nothing to do with carrying a weapon. What your citation is wrong. Would you like to try again? Branca's volume is low. Okay, I'll boost it up. You're right, it was low. I'm sorry.
And suggested he had killed Metcalf in self-defense. Actually kind of asked the question, pondered whether it might have been self-defense. So we have some new information now, and we can explore a little bit more of Texas law, and that's our purpose for all of us today. So as I am prone to do, I did do a couple of quick polls on this, one on Twitter. I asked, what likely verdict do you think the police report will support? Now, Karmelo Anthony has been charged with murder, obviously an unlawful killing. He's going to be claiming self-defense, a justification for that killing, which would make it not a crime. So we're looking at either murder or a justified homicide, or potentially somewhere in the middle, what might be a voluntary manslaughter. So we'll talk about all of that in the context of Texas law applied to the facts of this case. So here's the first poll on Twitter. What verdict do you think the police report will likely support? Justified self-defense, 4%. 4% of you.
Yeah, not right now. Justified
mitigated manslaughter, which is manslaughter is a voluntary manslaughter, is a mitigated form of murder. And simply cold-blooded murder, that is 77% of you. And
based on the information presently available, 77 is an underestimate. Based on the information presently available, it's more like 90-10 at best.
YouTube, the results were pretty similar. 2% think the police report will support self-defense. 15% mitigated manslaughter, and 83% cold-blooded murder. Now, I have not read the police report yet. What I've seen of the facts so far, independent of the police report, is making murder look pretty good. In fact, before we look at the police report, why don't we actually take a look at the criminal statutes so that we're looking at the facts with an understanding of what the law requires. So for the crime of murder under Texas law, I'll pull that up in just a moment. Now, I do want to remind all of you, to please, if you like this content, subscribe. It's free, and we're darn close. Well, we just broke 180,000 on this morning's show. Now we're at 180,000.
Good for you, man. You're doing better than me, Andrew. So, again, upstaged, man.
280. Our goal is 1 million subscribers. We can only do that with your gracious support.
The relevant part is 931B5A and B. All right, fine. Let's take a look. 931B5. All right. 931. The use against a force against another is not justified if the actor sought explanation from or discussion with another person concerning the actor's differences with the person. How is 5 triggered? How are you getting, if the actor sought explanation from or discussion with the other person concerning the actor's differences with the other person? I'm not sure how you're even getting that far. If the actor sought explanation from or discussion with another person concerning the actor's differences with the other person, I don't think that works. I don't think that's right. That sounds wrong. I don't think that's correct. So I don't think Section 5 applies.
You can hit that subscribe button. I would really appreciate it. And click that thumbs up like button too. That's what convinces the YouTube algorithm to share our content more broadly. Okay, let's take a look at some Texas statutes. I've got them prepped here. What do we got first? Murder. Texas Penal Code 9.0.
By going and sitting with the other team? How does that have anything to do with anything by going and sitting with the opposing team? What are you talking about? You think that's provocation by itself for the fight? I don't know. I don't think so.
2. It's kind of a jumbled statute.
Yeah, you have to make, yeah, I mean, you have to get past, you have to, in order for 5A to apply, 5 has to apply. You can't get to 5A without getting through 5. You can't get to 5A without getting through 5. So if it's not an actor seeking explanation from another or discussion with the other concerning the actor's differences, if it's not that, then you can't even get to 5A or 5B. You can't get past 5 to get to 5A. It's not how that works. I just mentioned asking because it's mentioned by other lawyers. Yeah, but I don't see how you get past 5. It doesn't make sense to me.
We're going to skip this part 8 to get to the actual crime here. What does it take to have committed murder under Texas law? Well, you commit the offense of murder if you intentionally cause the death of an individual. That's one way to commit murder.
Still waiting for that citation, by the way, that the mere fact that the weapon was illegal and or that the knife was over 5.5 means that self-defense is gone. Still waiting for that magical citation that if the knife was over 5.5, it means that he loses the claim of self-defense. Still waiting for that one. I'd like to notice that, not so much on that so far. So, but, keep digging. I'm sure you'll find your citation eventually.
Did Karmelo Anthony intentionally caused the death of Austin Metcalf? Well, he stabbed him in the chest, stabbed him in the heart with a knife. You're presumed to intend the natural consequences of your conduct. You stab someone in the heart with a knife, you're likely to kill him, so you're intending the natural consequences, their death. That's murder. Now, importantly, it's murder unless it can be justified as self-defense. Self-defense is
subsection O. Subsection O. Well, 931 doesn't have a subsection O. It stops at F. So you're not giving me enough to look it up. You're not giving me a full citation. Subsection O of what? I hate you.
This conduct. If you did this, if you intentionally stab someone in the heart with a knife, but you can meet the conditions of the self-defense justification, then this is not a crime. It's not always lawful to kill people. Sorry, it's not always unlawful to kill people. If they're killed in lawful self-defense, the killing of another person is simply not a crime. Or alternatively, you commit murder if you intend to cause serious bodily injury and commit an act clearly dangerous to human life that causes the death of an individual. I think we're well beyond that with the stab to the heart here. Then they have felony murder. That's not relevant here. And then they have if you kill someone with illicit drugs, controlled substances, like you give them an overdose or something, that would all qualify as murder. Murder isn't a felony offense of the first degree under Texas law.
46150. All right, fine. Let's look up 46150 and see if it gets you anywhere. Hold on. $46.15. Okay, 4615, non-applicability, subsection O. A person may provide notice that firearms and weapons are prohibited from the premises. Okay, noted. And what? 931? We read 931. Which part of 931? We already read it. Which part of 931 do you want me to take another look at?
I'm not super familiar with Texas sentencing. I looked it up. A felony of the first degree in Texas law is good for 5 to 99 years or life.
Yep.
Now, obviously, I would not expect a intentional murder to get a sentence of 5 years. There must be more to the sentencing structure than that. But Karmelo,
there's really not. There's really not. It's 5 to 99. That's the number.
Anthony is looking prospectively at 99 years or life in prison. What about manslaughter?
Isn't it a felony to bring knife to a school? Yep, sure is. Yeah, bringing the knife to the school might in fact be a violation of a different law. Yeah. The possession of the knife is a crime. Yeah, noted. Correct. And therefore, what?
Well, Texas does have a separate manslaughter statute. This is kind of an interesting facet of Texas law, actually. Let me pull it up. Most states that have a manslaughter statute will define both voluntary manslaughter and involuntary manslaughter in the manslaughter statute. Texas doesn't do it that way. It has both crimes, but the manslaughter statute...
Section 931 says self-defense isn't available if you engage in a crime at the time of the incident. Well, let's see. Section, oh no, hold on. 931, I'm in the wrong section. 931. The word crime does not appear at all in section 931. So 931 does not take away your right to self-defense if you engage in crime, because the word crime literally does not appear in 931. So no. I mean, I don't know what's hard about this. You do understand in law that like the words matter and we actually have to go read exactly what it says and understand exactly what it says. Okay.
Penal code only refers to involuntary manslaughter, which is reckless manslaughter. We see that here. A person commits an offense, manslaughter, if they recklessly, not intentionally, but recklessly cause the death of an individual. Recklessness is when you knowingly create a risk of death to someone else, like drunk driving, you ignore that risk and someone dies as a result of your conduct. Also, if you're mishandling a firearm. Like
you saw criminal activity? The actor's belief that force was immediately necessary is presumed to be reasonable if the actor was not engaged in criminal activity. That doesn't mean it wasn't reasonable. It's not a bar. It's just presumed to be reasonable if they're not engaged in criminal activity. Right? So you're in the wrong section, right? Because section B deals with it's not justified. Section A deals with the actor's belief is presumed to be reasonable if they were not engaged in criminal activity. So if he's engaged in criminal activity, there's no presumption of reasonability, but it doesn't mean it can't be reasonable. It's not a bar. It's not a bar. If it were a bar, it would be in B, not A. So you're misreading the statute.
That would be a reckless manslaughter. Instead of defining the other form of manslaughter, voluntary manslaughter. So in reckless manslaughter, you're not intending to harm anybody, right? The person driving home drunk from the bar isn't intending to harm anybody. He's just trying to get home. But he's engaged in reckless conduct, and if he kills someone, it's reckless, involuntary manslaughter. His use of force against that person was involuntary. The other kind of manslaughter is...
He sought discussion by going to their seats? No. You believe that me sitting next to you means I'm seeking a discussion from you? How are you getting to that? How are you getting to that? You think me sitting next to you means I'm seeking a discussion? How are you getting to that conclusion? That's dumb. Do you think before you say things or what? Every time you go to a baseball game or a football game and you sit in the stands, you're necessarily seeking a conversation with the people that sit next to you? Is that how that works? Every time you go to the park and you sit on a public bench, you're seeking a conversation with anyone who sits next to you? Is that how that works? Sitting next to someone automatically means you're seeking a conversation? Oh, okay. I didn't know that.
Voluntary manslaughter, where you're intending to use force against that other person. What makes that, and then they die as a result. Texas doesn't put voluntary manslaughter in the manslaughter statute. I'm not sure why. Instead, in a rather complicated way, it actually buries it in the murder statute for Texas. So let's go back and take a look at the murder statute. Now, the concept is the same. It's just a weird way of them structuring the law like this. So we already talked about murder. Here's the murder statute again. But if we go all the way to the bottom here, we have this paragraph D. Now, voluntary manslaughter typically occurs when you want to cause harm to someone. Maybe you even want to kill them, but you're acting...
According to the government, if you're in public, you no longer have the right to privacy. I think they could make an adjacent argument. What the fuck are you saying? Are you retarded? We're going to have an IQ limit to be a part of this chat or something, I swear. Yes, LMAO. Well, then, maybe you should seek someone else. I mean, come on, damn.
What's called adequate provocation. You're acting in hot blood. You came home and found your wife in bed with another dude, or things escalated from a traditional fist fight to something more life-threatening than that, something that made it a hot-blooded killing instead of a cold-blooded, premeditated killing. The way, and it's the hot-blooded killing that mitigates what would have been murder down to manslaughter. The idea is that your heightened emotional state made it impossible for your mind to form the specific premeditation required for the crime of murder, so they mitigate it down to manslaughter. The way Texas does that is as so, in this paragraph D, at the punishment stage of the trial. So what this means is you've been charged with murder. You go to trial on murder. You get tried on the charge of murder. The jury convicts you of murder. Now you're at the punishment. The guilt stage of the trial is over. You've been found guilty of murder. Now the judge has to sentence you. This is the punishment stage of the trial, post-conviction. At that punishment stage, the defendant, now the convicted, can raise the issue as to whether he caused the death under an immediate influence of sudden passion arising from inadequate cause. So something that would have made anybody hot-blooded. If the defendant proves this is what happened by a preponderance of the evidence, instead of the killing being a felony of the first degree and potentially life in prison, it's mitigated down to a felony of the second degree, which carries a sentence of 2 to 20 years instead of possibly life in prison. So this is what most states would call voluntary manslaughter, a mitigated form of cold-blooded murder. Now, what is it? Then you have to go all the way back up to the statute to find out what they meant when they said adequate cause and sudden passion. It's a very weird way to structure a statute. Adequate cause necessary for a finding, a mitigation to manslaughter, would mean cause that would commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper. So not someone with poor emotional control, sufficient to render the mind incapable of cool reflection. So you're walking outside, taking your wife to dinner downtown, and somebody walks up and spits in your wife's face. Might that be adequate cause to produce a degree of anger, rage, resentment in a person of ordinary temper? It seems likely. And what does sudden passion means? Because the adequate cause has to have resulted in sudden passion, that hot-blooded state. Means passion directly caused, rising out of provocation by the individual killed, or another acting with them, which passion arises at the time of the offense and is not solely the result of some form of provocation. So it can't be some pre-existing animus, for example. That's what would be required to mitigate this killing from murder to manslaughter. And then, of course, we have self-defense, the legal justification. Now, people are making a big deal out of the fact that Karmelo Anthony, when he was arrested by police, immediately told them, yeah, I stabbed him. that doesn't make the stabbing a crime, and it's not inconsistent with lawful self-defense.
Yep.
Self-defense, the legal defense of self-defense, is inherently a defense of confession and avoidance.
Yes.
You have to concede that it was you who committed the use of force in order to claim self-defense. You can't say, it wasn't me, I wasn't there, I have an alibi, and also I did it in self-defense. When you're claiming self-defense, you're not saying it wasn't me. You're saying it was me, I did it, but I meet the conditions for that to be justified as self-defense. And those conditions, of course, are spelled out in the Texas Penal Code for self-defense. In this context, deadly force self-defense, because obviously deadly force was used. A knife to the chest is always going to be deadly force. Folks, I see comments and stuff in the chat, but if you're on YouTube and you have a comment or question you want me to address directly, it needs to be a $5 super chat minimum. That's just the way we do it around here.
That might be the best policy I've ever heard of. Maybe I should stop responding to chat unless they give me $5. It'd probably save my sanity. Something very much to consider. You don't get me to respond to you unless you give me $5. I like this policy. Then at least if you're saying the stupid, at least I'm being paid for my time.
That's just the way we do it. If you're a law self-defense member, of course, just put your comment or question in the chat, in the members only chat, and I'll address it there. So what's required for a use of deadly force, the stabbing of Austin Metcalf by Karmelo Anthony? What's required for that to not be murder, not be manslaughter, but to be lawful self-defense? Well, it could be, sorry about that, I'll make it a little bigger again. It could be a justified killing, not a crime. If Karmelo Anthony, first of all, would be justified in using non-deadly force. Beyond that, if Karmelo Anthony reasonably believed his use of deadly force was immediately necessary to protect him against Austin Metcalf's use or attempted use of unlawful deadly force. So if Austin Metcalf was conducting himself in such a way that a reasonable and prudent person would have believed he was about to use deadly force upon Karmelo Anthony, then Karmelo Anthony would be legally privileged, justified in using deadly defensive force. Another way to put this is that Karmelo Anthony stabbing to death of Austin Metcalf would be a justified homicide and not a crime, not murder or not manslaughter, if Karmelo Anthony committed the stabbing in the reasonable perception that Austin Metcalf was about to bring unlawful, imminent, deadly force against Karmelo Anthony. And the question then for us becomes, well, is there evidence to support that justification narrative?
Not really.
Is there evidence from which a reasonable person could have perceived that Austin Metcalf was presenting himself as an imminent, unlawful threat of deadly force harm to Karmelo Anthony?
Not really.
That required Karmelo Anthony to stab him in the chest, stab Austin Metcalf in the chest, and kill him.
No, not really.
That's where we're at. Those are the questions for us.
Does Branca understand does Branca understand about imperfect self-defense?
That would support a reasonable perception of Austin Metcalf presenting as an imminent, deadly force, unlawful threat to Karmelo Anthony.
If I get to show Andrew Branca up on imperfect self-defense, I'm going to feel pretty good about myself. I just have to say. Because Andrew Branca is the self-defense guy. If I show Andrew Branca up by being the one that discusses imperfect self-defense and he doesn't, I'm going to feel really, really smart. I just have to say.
And here we go. All right. Frisco Police Department. Arrest reports. Anthony. Oh, it's Karmelo Sincere. His middle name is Sincere. That's nice. Karmelo Sincere Anthony, age 17. Born in Baton Rouge, Louisiana.
He isn't discussing it because he doesn't think it satisfies the elements, but he knows it exists. Well, no. How do you know he doesn't know that it exists? He must have discussed it. He must have discussed it if he doesn't think the elements are there. So he must have discussed it. Okay. Yeah. He talked about it previously. Oh, okay. So which video am I watching then? I thought we were watching this video. Which video am I watching again? What am I being corrected on again? I don't even remember why we were doing this in the first place. I think we were doing it based on the issue of there being, I think what we were trying to do is go to the issue of him saying that he thinks that there was provocation by the stabby guy. I think that's why we originally started this, was to say what he thinks is the basis for provocation by the stabby guy. Isn't that originally why we did this? Imperfect still requires proportionality. I know it requires proportionality. I well understand that. I've talked about the fact the jury has to buy it many Many times I've like, yes, the jury has to buy that this makes sense. And I don't think they can. But he can make the burden of production because he can get past nothing. This is about concealed carry the knife being a crime, no possible self-defense. Okay, well, then we'll continue listening. He was committing a crime while committing the murder. What crime was he committing? And what is your basis for that in law? Is that true or not? I don't know. I mean, I don't see it in 931 or 932. I don't see it. That the mere fact you're committing a crime is a bar. I don't see it in 931 or 932. The mere fact you're committing a crime is a bar. Yeah, having a knife on school grounds, don't see it.
HEB started April 2nd. He started that day. The day he stabbed Austin Metcalf is the day he started his job as a cashier at HEB. I'm pretty sure he's not employed there anymore. Charged with Penal Code 19.02C. Let's see. 19.02C. Yeah, that's just murder, first degree murder. So, narratives, initial narrative. Officer Eduardo Cortez at April 2nd, 2025 at 10 o'clock in the morning.
Can I just skip his entire discussion of the police report? Because we already did the police report. So can I just skip his discussion of the police report and get to wherever it is that he's discussing what he needs to discuss?
Ground state. There's no duty to avoid. So it's only innocence, imminence, proportionality, and avoidance. Effectively, just 4 elements. Karmelo Anthony would have had to have been the innocent victim of imminent, unlawful, deadly force threats at the hands of Austin Metcalf. And there's not a scintilla of deadly force threat being offered here. Now, we might wish that we lived in a world where someone put their hands on you. That alone was sufficient to justify your use of deadly defensive force. John Wayne had something to say to that effect back in the day. I don't put my hands on another man, and they best not put their hands on me. All right. I do want to finish this up at the top of the hour. I have a business call I have to deal with. Let me take a quick look at the Law of Self-Defense member questions, and then I'll check out the super chats. It looks like we only have one so far. If you're on YouTube, and there's thousands of you, if you're on YouTube and you'd like a question or comment addressed by me during this live stream, it needs to be in the form of a $5 super chat, minimum $5 super chat. If nothing else, folks, if you could please subscribe. Our goal is to get to 1 million subscribers. We can only do that with your support, which you have been enormously offering us, graciously offering us your support. There it goes. Those numbers keep scrolling up.
No, I have to say, I have to be honest. I feel very, very frustrated in this discussion because, like, I feel very frustrated because I feel like I've gone out of my way repeatedly to say that this is not really a very viable grounds of defense. It's like it's thin. It's thin. And his odds are very poor. And I feel like I've gone out of my way to say that repeatedly. And I feel like some of the questions coming my way are treating me as though I've been saying, no, this is totally going to work, guys. This is totes going to work. It's definitely going to be fine. I feel like people are making rebuttals to an argument I'm not making. Maybe it's just all in my head, but that's how it feels. And it's very frustrating. And of course, one of the reasons, incidentally, that I have to keep open the possibilities, we simply don't have enough information yet. You know, we simply don't have enough information to foreclose the possibility. And so it's like, well, I have to keep it open because we don't have enough information to exclude it at this time. So, you know, I'm keeping my options open for the future. So, yeah. 935A, we've covered 935A. To get to 935A, you have to get through 5, and 5 doesn't seem to apply. So we've already covered that issue, and I'm not going to discuss it again.
See it. You're so kind. We couldn't do any of this without you. Please hit that subscribe button. Please hit the thumbs up, like button. That tells the YouTube algorithm to share our content more broadly. Things look grim. Grim indeed for Karmelo Anthony. Yep. It looks like there is no justification of self-defense, in which case this killing is simply murder in the first degree, looking at life in prison. Could there be a hot blood argument? A hot-blooded argument that this was manslaughter? I just don't see it. Adequate cause under Texas law to mitigate murder to voluntary manslaughter means a cause that would commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper to lead them to kill.
Andrew's getting subscribers faster than me, and this is also very frustrating. Andrew's subscriber count is going up way faster than my subscriber point count. I want to kill myself. Is the indictment public? I don't even think there is an indictment yet.
Is someone putting their hands on you, even grabbing you, would that commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper? Not someone with anger management problems, a person of ordinary temper that would lead them to kill. It wouldn't surprise me if the defense went for this angle because manslaughter sucks. It's still good for 20 years in prison, but it's a lot better than life in prison. So I expect they'll certainly be asking for the manslaughter. Well, I guess it won't be a murder instruction. Under the way Texas does it is you're convicted of murder, and then during sentencing, you argue to the judge that it should be mitigated to manslaughter. So I would expect that's what they will be doing. All right, law self-defense members. Let's see. No video yet. Law self-defense member Andrew says no video yet. Both sides are sure they know if it is or isn't self-defense. Yeah, it would be shocking a tent full of people that no one was rolling video at the time, given especially high school students in 2025. But apparently the cops did seize all the cell phones. So if there's video, they'll have it. Does tossing the knife go to consciousness of guilt? Yes, it does. Also, fleeing the scene goes to consciousness of guilt. Karmelo Anthony has raised $200,000 already on Give, Send, Go. Yeah, I mean, listen, everyone's entitled to a legal defense. If people want to give him money, and that's not illegal, it doesn't change the facts and the law of the case. By the way, I see a lot of people making a big deal out of the fact that Karmelo Anthony had the knife at the track meet. For some reason, that doesn't bother me that much. When I was in high school, granted, that was the 80s, but when I was in high school, I carried a knife in school every day in my back pocket, a buck knife. So to me, the knife doesn't bother me. It's the use to which the knife was put. Or if there's evidence that the knife was brought for malicious purposes, that obviously would be relevant. Zakuza says, sounds like a take your swing moment. Yeah, go ahead, punch me and find out what happens. Joe says, have you thought about covering the Doomsday murder trial out of Arizona? It's streaming live. I don't think I'm aware of it. Lori Vallow is representing herself. Well, I know that name. I'll have to look at it again. It's going to be hard for me to stream a trial right now with everything that's
Case of premeditation murder? I don't think so. Not based on what we know so far, no.
happening with Trump. At what point in custody does the suspect get read his Miranda rights? So you're supposed to be read your Miranda rights. The only time it's required to be read to you is when you're about to be interrogated, when the police are about to question you as a suspect. Until they're about to do that, they have no obligation to Mirandize you.
Right.
So if like here, it sounds like these officers got to the scene, made the arrest, transported him to the police department, to the jail, turned him over to the criminal investigation division, the detectives, and none of the officers engaged in any questioning of the suspect. So there was no requirement for Miranda. Now, before the detectives talked to him to question Karmelo Anthony as a suspect, they would have been required to Mirandize him. Let's see. Yeah, I mean, I'm sure when I was in high school, they must have had a rule against having a knife in school, but I mean, like teachers knew I had it. I would cut open packages for the teachers with it. Just nobody cared. All right, that's all the members. Let me see. We got a couple super chats. It looks like maybe. Sherry Lawlessness, $5 super chat says, does having a gun in school property matter? It could matter if the blade of the knife is more than 5.5 inches. Texas has a weird knife law that puts knives with blades in excess of 5.5 inches in a special category. A special category of weapon that could lead to a violation of a special weapon statute that could undermine a claim of self-defense. I would be surprised if the knife was that big. That's a pretty big blade, especially for a folding knife. And you don't need a big blade to cause this kind of injury. I've seen it done with little tiny Spyderco knives, paring knives in the kitchen. It's not that hard to nick the heart, unfortunately.
He says it could undermine the claim of self-defense, but he doesn't provide a reason why it could undermine it. He just says it. He doesn't provide a rationale. So, I disagree.
What about school zero tolerance policy on weapons? Again, unless it falls into that special knife category with a blade of more than 5.5 inches, it's just a knife on school grounds. That may not be permitted. I guess it could even be a criminal violation, but although I would be surprised. But if it is, that's just another criminal charge that could be brought against Karmelo Anthony. I don't know that it would have an impact on his murder trial or self-defense narrative. Let's see. And a $5 super chat from John355. Thanks for your explanations. I know this is hindsight, but what can Karmelo Anthony have done to avoid this outcome? Well, almost anything, right? Like not stab them. There was no reason to stab Austin Metcalf. None. And maybe not get engaged in hostilities anyway. If I was in someone else's tent, school tent, and a member of the school asked me to move, I'd probably just move. I probably wouldn't get into an argument about it. Especially as I suspect we'll hear that it was already raining, that people were under the tent to get out of the rain. And, you know, we never bring enough tents to these kinds of things, so space would be at a premium. Not everybody would fit, usually is what happens in my experience. And here's a kid from an unrelated school taking up space in the tent. That would be better put to use for someone.
Does Anthony need his parents present? No, he does not. Not in Texas, no.
School that brought the tent. So I don't find anything unusual about them asking him to leave. I've seen implications that maybe Karmelo Anthony was going from tent. Apparently he was not participating in the track meet. That maybe he was going from tent to tent to steal things. That's theoretically possible, but I would need to see evidence of that. If they find, for example, stolen items in his backpack, that would be evidence of that, obviously. A malicious motive for being there. All right, and that's all the super chats. And that's all I have for you with this update. Please subscribe if you're on a smart device.
So Andrew does not provide a rationale for his view that if the knife is over 5.5, it would undermine his self-defense claim. I don't know why that would be true. Yeah, it doesn't sound right. So I don't know why that would be true, but he doesn't provide a rationale. He just says it. So I guess I'll just disagree without a basis of, you know, a more precise reason, because I don't have a reason from him, so I can't really opine any further. Okay, and then we can watch the one from 3 days ago, because 3 days ago he apparently discusses this provocation issue or something. So we can watch this one for 3 days ago.
Welcome, everybody. Welcome to yet another episode of the Law of Self-Defense. And today we're here to talk about a very unfortunate event, a killing at a track meet in Texas, Frisco, Texas, in which one student stabbed and killed the other student. And as you might imagine, we've gotten a lot of calls here at Law of Self-Defense for our take on all this. The first thing I'll say, and I am, of course, Attorney Andrew Branco for the Law of Self-Defense, where our expertise is use of force law, self-defense, defense of others, defense of property, and so well suited to this particular topic. The first thing I'll say is we don't really have good answers because we don't really have good facts yet in this case. The correct legal answer to a reasonable degree of legal certainty is a function of applying the law to the facts, the law of self-defense. Now, we know the law, and we'll step through that here with all of you, but we only have the vaguest sense of the facts so far.
3320, thank you.
Once to settle their differences, well, mutual combat is a mutual consent to the use of force. It's a traditional fist fight. You're each agreeing, consenting to the other's use of a fist against you because you're planning to use a fist against them. That's what a traditional fist fight is. That's what mutual combat is. And if that's what you're engaged in, if that's what was being offered here by Marcelo Anthony, he has no claim of self-defense, not even for the use of non-deadly force, much less a knife to the chest. Another exclusion, if the defender provoked the other's use or attempted use of unlawful force. So even if there's evidence that Austin Metcalf put hands on Marcelo Anthony, if that was the result of provocation by Marcelo Anthony, then Marcelo Anthony cannot claim self-defense here.
Right.
Because he provoked the encounter. He can't claim self-defense for having provoked the encounter unless he does something particular. It says here, unless he had abandoned the encounter and attempted to retreat from the encounter. And then Austin Metcalf had pursued Marcelo Anthony. Then Marcelo Anthony would have reacquired a privilege of self-defense. But none of that.
You said 32? I apologize. You said 3220? I apologize. I misread it. My fault.
Use or did use any physical force against Marcelo Anthony. The use of force against another is not justified if the defender consented to the exact use of force attempted by the other. What else did we hear from the twin brother? That effectively, Marcelo Anthony challenged Austin Metcalf to do something when he refused to move out from under the tent. Well, that sounds a lot like mutual combat. Make me. Or provocation. I dare you. Go ahead. If it's mutual combat, if Marcelo Anthony is extending an invitation to Austin Metcalf to engage in physical violence to settle their differences, well, mutual combat is a mutual consent to the use of force. It's a traditional fist fight. You're each agreeing, consenting to the other's use of a fist against you because you're planning to use a fist against them. That's what a traditional fist fight is. That's what mutual combat is. And if that's what you're engaged in, if that's what was being offered here by Marcelo Anthony, he has no claim of self-defense, not even for the use of non-deadly force, much less a knife to the chest. Another exclusion.
Yeah, I mean, he's not wrong on theory, and so it just becomes which way do you break on the issue, right? So we agree on the principle. We agree on the principle, and it's just which way of the way do we break on it? You know, do you break this way or do you break that way? And so, you know, it's not like Andrew's like wildly out of pocket for suggesting it, and I've already said as much. Like it's going to be something that's going to be fought over. It's like, yeah, it's like, and I've already said like I'm not the foremost expert on the issue of provocation. It's like I think the safer course of action for me at the moment is just to assume it's not true. It's like that feels safer, you know, that to leave open the possibility. It's like, is that provoking a fight? It could be understood to be provoking a fight. It's not unreasonable to say it, but it's like an issue about which way do you break. And also even somewhat more the point, I suppose, in the end, like, is a court really going to preclude it? Or are they going to present it to the jury and let them find it as a matter of fact? I mean, they're almost certainly, one would imagine, almost certainly going to present it to the jury and let them decide the issue about whether it's provocation or not. So I think ultimately at the end of the day, the jury is going to have to decide whether that qualifies as provocation to the fight. And then it becomes just a question of fact about which way do you break on the analysis, you know, and then, you know, who knows where you go after that. So I don't know that we disagree in some substantial way, you know. And I've already said, like, I've already gone out of my way to, like, you know, whether it's on the issue of provocation or it's the issue of proportionality, you know, I've already like said, like, his odds are not favoring him. He's already on the short end of the stick. So if Andrew thinks it's more likely to be provocation than I do, then I would just chalk that up to a disagreement of opinion. It's like, it's just like, well, where do we think we are? You know, where do we think we are in this continuum? And so we're just like breaking slightly different on our assessment of the facts. I'm just trying to like, which way do we break? So it's a very like, it's just a, you know, and also to both of our credits, we're both operating in a zone of uncertainty because we don't have enough information, you know. So we're both assessing the issue of provocation based on an incomplete picture at this point. So yeah. So I mean, yeah, I think I think the safer assumption at this time is to assume that it does not legally qualify as provocation. So I think that's the assumption I'm going to go with for the moment, is that it's not provocation. Subject to change in the future. Yeah. Things are not going well for him. You know, now, incidentally, as someone mentioned that these people might have history. And that history could break both ways depending on the nature of their history. So if these people had history together, that could potentially break either way depending on what the nature of the history is. So we'll see how it progresses, but we don't have enough information at this time. Lawyer, police report exposes truth about time stabbing. Well, let's see. Timestamp 32. Yeah. Let's see.
Welcome, everybody, to another episode of The Law of Self-Defense. Here to talk about the tragic stabbing in Frisco, Texas that occurred at a track meet just about a week ago today. And we have some news. In high school, a weapons call was dispatched that detailed a stabbing at the stadium. After hearing more dispatch call information, I drove to the scene. While en route, I heard Officer Cortez said he had a suspect in custody. On scene, I looked for Cortez, went straight to him to hold security with the suspect. He had cuffed and secure in the police squad. Multiple witnesses were providing statements to officers where the stabbing occurred. Only a short time later, Officer Cortez and myself escorted the suspect, Karmelo, Sincere Anthony, to the Frisco Adult Holding Facility. Anthony was transitioned to the jail staff without incident. Next, Officer Alvin Fisher. On April 2nd, about 10:05, I was dispatched to the stadium in regards to a stabbing.
You know what? I give up. All right, I give up. I give up. It's just murder. There's absolutely no defense of any kind. It's absolutely just 100% through and through murder. There's absolutely no possible defense in any way, shape, or form. This is as clear-cut murder as it can possibly be, and he's going to be convicted, and he's probably going to get life imprisonment for this obviously cold-blooded murder without any cause. Are you guys happy now? Are you happy? Damn.
When I arrived, the crime scene was already marked off, suspect in custody. I began asking people if there were witnesses to anything. I made contact with witness Hunter and then another witness. They were both breathing heavily and crying due to the nature of events. They were with coaches on the field and it was pouring down rain. We made the decision to relocate to a locker room just to the east to get out of the rain. Once in there, things calmed down a little bit. However, they were still hysterical and could not really talk. In there, I learned Hunter was the brother of the victim. So this is Austin Metcalf's twin brother, who held him in his arms as he died. I attempted to ask both of them what happened. I could not really get anything out of Hunter, but the other witness stated he wanted to speak. He stated they were all sitting on the bleachers under a Memorial High School tent when another male, who he did not know, walked over and sat under the tent. Witness then said Austin, the victim, told this male that since he did not go to Memorial, he had to leave the tent. Austin and the male went back and forth, and then Austin stood up and pushed the male to get him out of the tent. Witnesses said during this time of arguing, the male was reaching around in his bag he had. It was at this time the male took out a knife and stabbed Austin and then left the scene. This was all the witness remembered when he talked to me. After this, I stood with 3 athlete witnesses until the Criminal Investigation Division arrived and interviewed them. Next officer, Mike Crawford.
There's nothing here. There's nothing in this video at 32 minutes. All right, I've chased this rabbit hole enough. I'm done for the day. Thank you for participating. It's been fun and all. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.